question is, so I guess we'll use this to change this. Okay. All right, thank you, Manisha, very much for that introduction and for moderating for us. And thanks to the Canadian Animal Law Conference, to Angela, of course, to Camille, to Sarah, their teams, Animal Justice, and of course the Brooks Institute for sponsoring this day. And also thanks to Macarena. She and I have been working together on this project for a year. It started with an Ecuadorian case we'll talk about, but we only actually met in person here today. She and I will present different parts of the presentation. It is the basis of a draft article that we hope to finish up in the near future. So we welcome comments, critiques, any thoughts to strengthen our project. We're very open to hearing everything. You know, the harsher the better, right? to strengthen the project. So, by way of introduction, there's a few observations we have, which is that achieving animal rights faces many obstacles in really all jurisdictions. I mean, we do see some movement, some progress. And of course, it depends on how you define rights, to say if animal rights exist or don't exist in any jurisdiction. But generally speaking, there are many obstacles to the achievement of some kind of full animal rights that we may think of in a fulsome sense. At the same time, rights of nature are emerging worldwide. The concept is emerging worldwide. And there are reasons to be skeptical of rights of nature, regardless of your perspective. If it's an environmentalist, if it's a earth law person, and especially, as we are today here, particularly, if you're an animal law person or an animal law advocate, there are reasons to be skeptical. We'll talk about that. But there are also important wins that have been based on the rights of nature, which makes it something that we can't ignore. Okay. So, for example, we have Aotearoa, New Zealand, a river, where rights of nature in this jurisdiction has really developed via legislation. So typically, this kind of legislation has developed from negotiations between the government and the Maori tribes, resolving historic breaches of the treaty that was Aotearoa, New Zealand's founding document. And so what happens, as in the case of this river, the river has been declared in what's been called the Wanganui River Claims Settlement Act, 2017. It declares that the river, quote, from the mountains to the sea and all its tributaries and ecosystems is a legal person and has all the rights, powers, duties, and liabilities of a legal person. So that's one way in which the rights of nature have presented themselves, negotiated by treaty, specific to a river. There are other rivers in New Zealand that have similar situations, similar statuses. And we also have a case in the country we're going to be talking more about today, in Ecuador. And this is a forest, and this rights of nature win comes not from legislation, but rather the Constitutional Court, which relied on rights of nature language in the Ecuadorian Constitution, and we'll get to that language in a little bit, to stop mining activities in this forest, which is home to many species of animals, some of which are endangered. So these are just some examples of achievements we might call rights of nature wins. But what do they have to do with animal rights? So let's go a little further into the rights of nature before we circle back around to the question of the role of animal rights.
So in jurisdictions worldwide, normally nature is regulated as property. And environmental law focuses on regulating humans' use of natural resources. So traditionally, the law has considered the right to a healthy environment as a human right. So for example, the Stockholm Declaration says, and emphasis on this, man has a fundamental right to freedom, equality, and adequate conditions of life, and an environment of quality that permits a life of dignity and well-being. And he bears a solemn responsibility to protect and improve the environment for present and future generations. And from this declaration on, different countries around the world started to regulate the incorporate into the Constitution this right to a healthy environment. Regarding like the rights of nature as a framework, Western thought, we can say that has generally opposed culture to nature, right? So viewing nature as something foreign that we can control and dominate. And this view has contributed to the destruction that we see around us and these pressing issues such as climate change. And in this sense, viewing nature versus culture is in a way not considering that nature is an interconnected system. And obviously we know now, because there's a lot of research on this topic, that humans aren't the only animals to have cultures. But as we know, so environmental law hasn't been able to stop this destruction that we see around us. And many believe that we are in a new current geological epoch called the Anthropocene that's characterized by, well, climate change, deforestation, and many, many other pressing issues. So the rights of nature appears in this situation as a way to stop with this destruction. And it's like a new paradigm within the legal system to kind of change this situation. So the rights of nature has incorporated indigenous traditions' view on their relationship with nature, regarding the protection of nature as well as humans' interconnection with the rest of nature. So indigenous traditions view human as a part of nature with other living and non-living beings. But the rights of nature also involves a second part, that is the Western discourse on rights. So the idea that nature or a river or a forest or even animals should be protected and that nature should have the right to thrive and to exist isn't new to indigenous peoples. And so we can find different positions regarding the rights of nature. So some indigenous peoples are against the rights of nature because they consider that it is a Western response to the West's destruction of nature, while other indigenous peoples around the world are using the rights of nature and promoting them in their countries to protect their territories and protect animals. So we can find different opinions on this aspect. Regarding like the Western development of the rights of nature, like an important milestone we can find was when Christopher Stone's influential article, Can Trees Have Standing?, inspired the dissenting vote by Judge William O. Douglas in the case Sierra Club v. Morton, where Sierra Club opposed the development of a resort in the Mineral King Valley in the Sierra Nevada mountains. So in this map, we can see different places around the world, like cities, towns, indigenous nationalities that have in some way recognized the rights of nature in their legislation. But this is not the only case, because also courts around the world have had an important part in developing the rights of nature. So for example, courts in Colombia, courts in Ecuador, courts in New Zealand, among others, have started developing this rights of nature framework.
Okay. So the question then becomes, as we see the expansion, the diversity of rights of nature, is should we use the rights of nature to assist animal rights? So our position coming into this project is not to think about in some abstract, theoretical, philosophical sense whether or not the rights of nature are a good construct for the benefit of animals, animal protection, animal welfare, animal rights, but rather to acknowledge the reality, which is that this phenomenon exists. And we see it not only in the countries Macarena mentioned, but potentially in new contexts as well. Our sense is that it's growing, it's not stagnant, and it's not diminishing. So I think the question before us is, as animal protection communities, what do we do, right? Should we use this concept to assist our particular endeavors? So what are the positives? Well, as I mentioned, fast expansion and social and political support, especially in countries in which there's a confluence of interests between environmentalists turned rights of naturists and indigenous traditions, which can happen. Those two communities can also be working in tension. So it's not only a one-way street. There is the opportunity, as we'll talk about, to include animals as individuals in the rights of nature. And I think that's a really key point. Without that opportunity, you might say skeptically, well, aren't we just talking about environmental law all over again with attention to endangered species or other groups of animals? And then we believe that the rights of nature and animal rights can complement and reinforce each other. So there are definite pros. So what are the cons to this? Well, it's difficult to define nature. It's an unstable referent, right? If you want to champion the rights of nature, what are you talking about? And will that be received the same way in different contexts? If we have this unstable referent of rights, we may not know what we're getting, right? If we go into a situation and advocate for the rights of nature. So that instability is quite significant and quite important. And can't really be minimized. And, to say it in a different way, nature does not mean the same thing in all contexts. There can be competing interests within nature. So is a river and the fish who live in the river, if they both have rights, what kind of conflict might they have? And then we bring in the communities who live along the riverbanks who may want to fish, and you have all of a sudden in the mix many constituents all arguing that they have rights derived under the rights of nature, and they conflict. However, I'll add as an aside, that happens all the time with rights. Rights often conflict, and it's up to courts to figure out how to sort out multiple rights at play all at the same time. And there are specific potential conflicts between rights of animals and rights of nature. I mentioned the fishing case. We can think of many other ones, invasive species and a habitat. So there are specific potentials for these kinds of conflicts in particular. So that's all true, and we could talk a lot about the pros and cons, but again, because we're taking a more pragmatic view in this endeavor, we also have to recognize that time is not on our side, right? We don't have a lot of time to hash out all the fine details, perhaps before plunging in to this particular endeavor. All right, and so now we're going to turn our attention to Ecuador and specifically and lead you through a little bit of history, a major case, and then hot off the presses, a fascinating new case on habeas corpus, which Jess is going to love, and she's so sad she has to leave, but you'll get the recording. I know she was going to love this case, and a new draft law. But first, let's talk a little bit about the context.
Okay, so since colonial times, Ecuador's economic model has depended on the extraction of natural resources and thus on the destruction of nature. So something particularly important for the society of Ecuador is the destruction of the northern Amazon by the oil industry. And this motivated a class action in the 90s against Chevron Texaco. So remember this case because this is like the case that made the Ecuadorian society support the rights of nature later on when it was included in the constitution. So during the 90s, an indigenous group called Confederation of Indigenous Nationalities became a decisive electoral and political force in Ecuador. And additionally, in that time, in 1988, the Constitution incorporated the right to a healthy environment in Ecuador. But the thing is that the government continued promoting the extraction of natural resources, especially the oil industry and mining, and he even declared those activities as national priorities. So the destruction continued. And so climate change, biodiversity loss, flooding, the expansion of the oil, livestock, mining, road borders expanded, and Ecuador suddenly was the country in Latin America with the worst deforestation. So these are some pictures of the oil industry in Ecuador. So as you can see, this is an oil facility in the Amazon. As you can see, they have to destroy a big part of it to install these facilities. Here we see the effects of oil spills in the Ecuadorian Amazon. And the picture with the frog is a picture that was taken on February 29, 2008, and it was an oil spill in the Trans-Ecuadorian pipeline in the province of Napo, Ecuador. And so all this problem with the rights of nature, with oil spills, led to people, especially indigenous communities, to protest. Okay, so this photograph you're seeing, we're seeing here women of the Confederation of Indigenous Nationalities of the Ecuadorian Amazon. And they represent more than 1,500 communities in the Amazon. And so the signs that they're holding say the following. The first says, Confine, which is the name of this association, resist. And it says #NoDAPL, which means that these indigenous peoples were supporting the process in the US of indigenous peoples that were protesting against the Tacuda Access Pipeline. And the second sign you see, it says Women for Life, #Haku. And Haku means in Quechua, let's go. And it's an indigenous saying to encourage their peoples to advance together. And in the final sign, it says kind of like long live life, down with oil. And well, it says against that the Confederation resists. So in this context, President Rafael Correa was elected in 2006, and he convoked a constitutional assembly that started drafting the new constitution in November 2007. There were three main factors that influenced the rights of nature in the constitution. So first, this president had like a governmental plan that was called Alianza País that incorporated many topics that were later on included in the new constitution. For example, he was talking about promoting a new society, a new democracy based on the principle of good living that I'll explain in a few minutes. Second, the influence of the Confederation of Indigenous Nationalities, which I mentioned before, had a strong political force. And three, the social movement against extractivism because of the problems with the oil industry in the Amazon. So the Constitutional Assembly's majority report stated that the rights of nature represented a need to redefine the relationships between economy, society, and culture with nature, and that they were going to redefine this through the principle of good living. So what is this principle of good living? So in Quechua, it's called Suma Causai. In Spanish, Buen Vivir. And in English, good living. I'm not quite sure, but good living. Let's say good living. So this is a principle that says that we should live in harmony with everything that surrounds us, with other humans, with animals, with elements of nature that are not even living. And it means to let go of the I, to recognize that we are a we, and that we live in a community that is interconnected and that we are interrelated with every other aspect of the planet. So this principle influences everything about our lives. It means that we have to think about our social lives. It means that we have to think about our consumption habits. It means we have to think about our relationships with our neighbors, with animals around us, etc. So another interesting thing is that during the constitutional process, the Constitutional Assembly allowed citizens to come and give their opinion on the diverse matters that were being debated by the assembly members. So in 2008, a group of people went to the assembly and suggested incorporating animal rights into the new constitution. And this added to the fact that some assembly members were environmentally aware, especially the president at that time, whose name is Alberto Acosta, triggered the debate on the rights of nature.
That's the president of the Constitutional Assembly.
Yeah, the Constitutional Assembly. So during the debate on the rights of nature, you can probably imagine that there were two opinions on this. So some people said that they were against it because nature can't be a subject of rights. They were saying the Constitution should recognize that humans have duties to protect nature, but nature can't be a subject of rights because, well, only humans can be subjects of rights. That was one position. And the other opinion was that the rights that viewing nature as independent elements that you can exploit and get economic benefit out of has led the country to this situation of extended destruction. So we have these two positions. And after all this debate, this is what we ended up getting in the new constitution. So Article 71 is the most important one, and I will read it. So it says, nature or Pachamama, where life is reproduced and occurs, has the right to integral respect for existence, for the maintenance and regeneration of its life cycles, structure, functions, and evolutionary processes. And remember this part that I'm going to read because it's going to be imported further on, but it says, all persons, communities, peoples, and nations can call upon public authorities to enforce the rights of nature. To enforce and interpret these rights, the principles set forth in the Constitution shall be observed as appropriate. The state shall give incentives to natural persons and legal entities and to communities to protect nature and to promote respect for all elements comprising an ecosystem. So, now, how did, we're going to talk about a case that reached the Constitutional Court in Ecuador. And we're going to see how the Constitutional brought together individual sentient animals with the rights of nature. So the case is about Estrellita, a woolly monkey. Estrellita was poached when she was 1 month old, and she lived with a family for 18 years, a human family. So probably she was poached by the illegal pet trade because it's a common issue in Ecuador with monkeys like Estrellita. So a neighbor anonymously tipped the environmental authority and said, hey, there is a monkey living in that private home. So the environmental authority confiscated Estrellita because in Ecuador you can't breed, sell, or have a monkey in your house unless you have like a wildlife license. That wasn't the case. So she was confiscated and they put her in quarantine in a zoo. And when she arrived at the zoo, the vet issued a report on her health. And he said that Estrellita was very aggressive, that she was malnourished, that she was underweight, that she had hair loss, that she had depigmentation of her skin, and several other things. The thing is that Estrellita died a month later. So she only spent a month in the zoo and she died. So the vet that issued the report when she arrived at the zoo issued the autopsy. There was no independent autopsy. And the autopsy said that Estrellita her lungs, her liver, and her kidneys failed, causing a cardiorespiratory arrest. And the report says that confiscated animals usually have this pathology that they've been developing through their lives, and that this is due to a bad diet, to bad environmental conditions, to mistreatment, to confinement, among other things. So as I mentioned, there is no independent autopsy. We only have the zoos. So I would say that Estrellita didn't arrive in the best conditions at the zoo, but that putting her in a zoo without considering her history led to her quick death. So in fact, the Constitutional Court recognized in its judgment that Estrellita's rights had been violated in 3 different moments of her life. 1, when she was poached and separated from her non-human family. 2, when she was forced to live with a human family for 18 years. And 3, when she was confiscated and put in a zoo without considering her personal circumstances. Before learning about her death, Estrellita's family filed a habeas corpus on her behalf. And the lower court and the Court of Appeals denied the habeas corpus, arguing that first, Estrellita had died, and second, that the habeas corpus is only for humans. However, the Constitutional Court selected Estrellita's case to develop binding jurisprudence. And this in Ecuador, that's a civil law system, means that the Constitutional Court's ruling is going to be mandatory for everybody in the country. And that's especially important because it's going to be mandatory for the Constitutional Court in future cases and also for other courts in the country. And this is important because the Constitutional Court's judges take changes every 4 years, I think. So if you could like modify that, if you get judges that are very, for example, conservative and against animal rights, they could just do something completely opposite to what the Constitutional Court did and state that case.
All right, so the Constitutional Court took this case along with, or we should say, a handful of others. So up until this time, the meaning of the Article 71 we showed you had not been determined or interpreted by the Constitutional Court. And so with some change over in the personnel of the judiciary, it seems most likely that these new judges wanted to start to develop some jurisprudence around this article that had been widely hailed internationally, but really had not ever been put into action by the Constitutional Court. And there was a lot of uncertainty about its meaning. So this was not the only case that was that was taken by the court at the time. And the Constitutional Court issued, as is their procedure, a short document saying, we've taken this case, and these are the questions we intend to answer through it. The first, can an animal be considered as a subject of rights? What is the scope of the writ of habeas corpus in relation to the protection of other living beings? And 3, can non-human animals be considered as subject of rights protected by the rights of nature? So 1 and 3 are related, but 1 is sort of in general, can they be the subject of rights? And then 3 is essentially, can the rights of nature make animals the subject of rights? That is, can they come in through the rights of nature door, so to speak? Question 2 was interesting, and we weren't sure why they were asking it, because of course that issue really was moot, just to use our American terminology, in the sense that Estrelita had passed away. So at the time the court issued this document with these questions, that's when we came into the picture. And an Ecuadorian attorney named Hugo Echeverria contacted myself and the Non-Human Rights Project and said, we have this case that's really important and it involves things that you are interested in. Would you be willing to write an amicus brief? And without thinking, for a second, we said, yes, of course. And we need also on our team a lawyer who is trained in a jurisdiction, either in Ecuador or similar to Ecuador, who understands animal rights, who ideally has a PhD. And Chris Green and I, the executive director of the Animal Law and Policy Program, were saying, we are yet again seeking a unicorn, as we often do when we have projects. And indeed, that's how we met. And it's been an amazing partnership. So Macarena and I wrote the section of the brief that dealt with 3 mostly, but also 1. And of course, the Non-Human Rights Project wrote about 2, but really we also contributed to that because we needed to have a consistent view. And our answers were, can an animal be considered as a subject of rights? Short answer, yes. What is the scope of the writ of habeas corpus in relation to the protection of other living beings? Yes. Broad, yes, other living beings can come under the scope of habeas corpus. And then a 3, also yes. Yes, animals have rights through the rights of nature, in addition to having rights in and of themselves. Okay, so our amicus brief responds to the court's questions. So I just gave you our answers, but we also added a few things. We said, and the relevant authorities should create protocols to guarantee the rights of animals under the rights of nature and habeas corpus. So we suggested to the court that while answering these questions the way we suggest is a good thing, that there also needs to be some detailed backing to them. So we requested protocols. And in arguing for animals are subject of rights and subject of rights protected by the rights of nature, we made a very particular point and spent a lot of time arguing that individual animals is what we're talking about. We can also talk about species, of course, but we really wanted to hone in on the fact that this is not a species case. This is an individual Estrelita case. And so we argued that when you look at a species, it's actually, they're made up of individuals, right? One by one by one. And then, so to try to put a number on how many animals are needed to trigger the rights of nature is not even a helpful question to ask. And we're happy to show you our brief. Macarena found some great examples where you only have a few animals left, right, of a species. And so, every single one matters. But even then, there's no dividing line between matters and not matters. Each individual life is important, and we really push that point. Quite strongly. Okay. So I will say a little more before turning it back over. So what did the court say? Well, basically, the court agreed with everything we argued and cited our brief extensively. So subjective rights, they recognize the subjective rights. The reasoning seems to be sentience. So the court pretty much states clearly that to them is why animals have rights, is due to their sentience. And while stating that all animals are subject of rights, the court also emphasized the rights of wild animals. And they did that not to exclude others, but because we think Estrelita was a wild animal. So it made sense to kind of push that. On individual animals, they accepted our argument completely. And the quote at the bottom, this is from the court, but they cited to our brief. I think this is our language, or it's almost our language. Protecting only the species of animals, neglecting the protection of individual animals, which in turn make up the species, endangers a significant number of animals and fuels the idea of the possibility of extinction, even in the case of animals whose species is not endangered. Neglecting or failing to protect individuals also has an impact. So that I think is the court's language, citing our brief. Now, it's important to note that this was a 7-2 decision. And I say that because we learn more about the Habeas decision from the dissent, which states more clearly what they objected to. And the majority does not state very clearly, in part, I think, because the issue was moot. Estrelita was deceased. But they do say, in a slightly vague way, habeas corpus can be appropriate for an animal depending on the circumstances of the case. So it really was a win on all of those. But there's some more to say. So the court brings up the interspecies principle and the principle of ecological interpretation. And the best way to convey this to you is through some choice quotes. So the interspecies principle that guarantees the protection of animals with the concrete grounding in the characteristics, processes, life cycles, structures, functions, and evolutionary processes that differentiate each species, right? So we're getting the sense that not every animal is going to have the same rights, and we're going to have some differentiation based on essentially what they need is the way I read it. And that's what we get here with the right to food of an Andean condor is not protected or guaranteed in the same way as that of a pink Amazonian dolphin, right? Since both species have different feeding demands and behaviors. So we know that not every animal will have the same kinds of rights. And here's the ecological interpretation. And I think detractors or critics of this decision have honed in on this particular part. So I want to give it a little attention before we go back to Macarena. So some quotes here. So what is this ecological interpretation? It respects the biological interactions that exist between species and between populations and individuals of each species. What does respecting biological interactions mean? It means that when a predator kills its prey in compliance with the trophic chain, so like the hierarchy, right, of who eats whom, the right to life of an animal is not illegitimately violated. So they are clearly stating that when predators, right, kill and consume an animal who is that species' prey, there is no violation. There's no rights violation there. But here's the kicker. Humans, too, are predators and are omnivorous, right? So, what is that supposed to mean, right? It's a great recognition that humans are predatory, right, as MH talks about and is working on, and they're omnivorous. So this sounds a little bit ominous here. Okay. So they go on to say the right of humans to feed on other animals cannot be forbidden, and food is a right established in the Constitution and in international human rights organizations. So did the court just issue blanket permission for all forms of eating animals? And our interpretation is no. So our interpretation is that this is an attempt by the court to make an exception, okay, in some way for humans eating animals, even though, of course, that wasn't the facts of the case. Why? Why is the court doing that? Why go out of their way when this is not a case about farmed animals or human consumption? So because this is the first case interpreting Article 71 on behalf of an individual animal, possibly in order for the court to declare that Estrelita has some rights, the court believed it had to set some general parameters for thinking about all human-animal interactions to maintain some legitimacy. And the court's legitimacy is a whole nother question that we'll be able to write about, but we don't have time to talk about here. The slippery slope argument obviously looms very large in any case involving a potential right of an animal. However, this language is not as categorical or as intractable as it may seem at first look. So what did the court do? It noted the biological fact that humans are omnivorous. This means that humans can physically eat and survive on both animal and plant matter. But human survival, if that's the guiding principle, is in grave danger due to climate change and other detrimental effects of the animal agriculture industry. So they're already setting up here a little bit of a contradiction that a wedge could be driven into it. And in fact, our survival, as we all know, really does depend on consuming fewer animal products. But here's the thing about this right language. To say that a biological condition, the ability to digest animal flesh, is a right that cannot be forbidden, doesn't use right in the same terms, in the same way as we've just talked about Estrelita's rights or animal rights. Right? More accurately, it's a statement that the court is not changing human biology. But just because humans are capable of eating animals doesn't mean that they must. And we know that humans indeed do not need animals to survive. Humans are also biologically capable of eating human flesh. But cannibalism is prohibited in most societies and would certainly not be part of this statement that the court has stated here. And I have no doubt that a court would uphold a law in Ecuador that prevents the eating of animals due to a breakout of BSE or other diseases in which the country has to stop the eating of certain animals. So we think the court walked a very fine line and said enough to cover itself, but not too much to prevent this developing later for other species, including farmed animals. All right.
So what positive effects have we seen in the months following the Constitutional Court's ruling in Estrelita's case? So in the ruling, the court said that he ordered the ombudsman in Ecuador to draft a law on animal rights and ordered the National Assembly, that's Congress in Ecuador, to approve this law within 2 years. So recently, like 2 weeks ago, the ombudsman submitted the law to the National Assembly. And the law is titled Organic Law for the Promotion, Protection, and Defense of the Rights of Non-Human Animals. The document is 66 pages long, so I will explain only 4 important aspects. We have to bear in mind that it's a bill, so it will probably change during the legislative procedure. So first, the bill includes all animals: companion animals, farm animals, service animals, animals used in research in the meat industry, animals that live in the wild, exotic animals, marine and aquatic animals, and liminal animals, and recognizes all of them as subjects of rights. It is very interesting to mention that the law does not refer to the animal's owner, but to the animal's tutor. So yesterday I searched the law for the words in Spanish for owner, and it doesn't appear once in the law. So that's like something new. Second, the law is an organic law. So in the Ecuadorian legal system, there is a hierarchy of laws. I don't know how it is in common law countries, but in civil law countries, there's like a pyramid of laws. So Article 425 of the Ecuadorian Constitution states that the hierarchy from the top of the pyramid to the bottom is the following. So the most important law is the Constitution, then international treaties, then organic laws, then ordinary laws, then regional laws, then decrees and regulations, and then other types of laws that it's not important for this case. So organic laws usually regulate important issues, and that's why they require a special quorum in Congress to pass. So Article 133 of the Constitution states that organic laws in Ecuador regulate 4 different topics. First, the institutions created by the Constitution. Second, the exercise of constitutional rights and guarantees. Third, the autonomous decentralized governments. And 4, the electoral system and political parties. So the Animal Rights Bill is an organic law because it regulates constitutional rights and guarantees. Why? Because the Constitutional Court's decision in Estrellita's case considered that animals are protected as subjects of rights by the constitutional rights of nature. So we're talking about constitutional rights. So an organic law is superior to an ordinary law and to decrees. So an ordinary law cannot contradict an organic law. In other words, the animal rights law would be superior to ordinary laws within the legal system, and those can contradict it. So this would help animal rights advocates in Ecuador because they could use this structure in Ecuador to challenge certain activities that exploit animals and that are currently regulated in ordinary laws or even decrees. So, third, currently in Ecuador, there is no law on animal welfare. There are some dispersed norms that say animal welfare is recognized in Ecuador and we apply the international standards of animal law, but there's not a law that specifically says farmed animals need this. That doesn't exist. So the bill on animal rights, it uses a confusing language because remember that the title says that promotion, protection of the rights of non-human animals, but at the same time, it's regulating animal welfare in different articles. And the law says in an article that guaranteeing animal welfare allows the exercise of animal rights. So we could explain this because it's probable that different NGOs in Ecuador helped the ombudsman to draft this law. So there are different interests going into this draft. So the thing is that, we all know that usually animal welfare legislation avoids using the term rights, even though some scholars argue that animal welfare legislation grants animals at least these weak rights. Some other authors say that these aren't really rights, but these are duties that humans must comply. So for example, in the case of Chucho, the Andean bear that started out as a habeas corpus that reached the Constitutional Court in Colombia, the court finally dismissed the habeas corpus and stated that Chucho wasn't a subject of rights, so he didn't have a right to welfare, but he was a sentient being because the legal system in Ecuador recognizes animals as sentient beings, but not as subjects of rights. Sorry, in Colombia. In Colombia. So Colombia recognizes animals and the law as, because Colombia modified its civil code And so it recognizes animals as sentient beings. But the Constitutional Court said that doesn't mean that they're subjects of rights. That means they're sentient beings, they're not subjects of rights, no right to welfare. So it seems like the Ecuadorian law is recognizing animals as subjects of rights and considering animal welfare as rights that those animals hold. So, and this will make sense now with the fourth aspect of this graph, is that Article 22 of the bill states that animals have the right to effective judicial protection, and as provided by the Constitution. So let's remember when I read Article 71 of the Constitution some slides ago, that it said that persons, communities, and nationalities in Ecuador can require the enforcement of the rights of nature. And in Estrellita's case, the Constitutional Court stated that animal rights under the rights of nature can be protected by different jurisdictional guarantees. I don't know what the concept is to translate it, but it means that we can use any action to enforce the rights of nature in Ecuador. That means the habeas corpus, that means the action for protection, that is another constitutional action, depending on the case. So in most countries, legislation that talks about animal welfare doesn't have a system where a person can present a claim, like a lawsuit to a judge directly saying, hey, those cows' animal welfare rights are being violated, do something. The procedure, for example, in Chile and in Spain, is that you have to go to the governmental agency and file like a claim there and say, hey, that farm isn't complying with the law on animal welfare. But what's the problem with the system is that that same governmental agency that now has to solve your claim is the same governmental agency has to inspect and enforce the animal welfare legislation. So obviously, if they say, yeah, you're right, they're violating the animal welfare, it's saying that they did their job horribly. And this is the case, for example, in a recent case that maybe you've heard of it because Cruelty Free International is involved. In Spain, there's a lab that's called Bibliotecnia that's funded by the EU, and there was a horrible case of animal cruelty going on. What was the problem? That the governmental agency that was supposed to enforce the European regulation on experimentation would go to the lab maybe twice a year, and when they went to the lab, they would sit in the meeting room with the staff, drink coffee, look at paperwork, and they never saw the animals. But now, obviously, they're not saying, yeah, you're right, like, cruelty free, you're right, we did our job wrong. No, obviously, they're saying there's no mistreatment here. But so in the case of Ecuador, people could go directly to a judge that would be an impartial party and say, hey, that farm isn't complying with the animal welfare legislation. And this may sound like a small win, but it's not, because you could go to a judge and use different actions like the habeas corpus or other types of actions. And so maybe it's a matter of time for somebody in Ecuador to file a habeas corpus for a cow, you know? And finally, there's a new sloth case, but we can answer that in the question.
Oh, new judgments. Okay, sorry. I just realized we're wrapping up sloth case, dogs and cats case, which I'll talk about, and then we will finish. Okay, so a very recent case issued just last week, very, very recently, in a lower court in Ecuador, granted habeas corpus for dogs and cats who were seized by the authorities. It's a criminal, very complicated criminal case, and the entire contents of the house of the accused were seized as potential evidence, including the animals. And I believe it was his mother, his wife who sought to have the return of the dogs and the cats. And the court, again, it's a lower court in Ecuador, but still, stated that dogs and cats are sentient subjects of rights protected by the rights of nature. So here we have domesticated animals. And this is for you, Angela. The court stated that the animals are not movable goods. They are not goods. And they really chastise the authorities who seized the animals and saying, like, what did you think they were? Like, you took them with everything else? They really chastise them and say they are not movable goods. They are not. They are subject of rights. They are not movable goods. You should not have seized them. And the court based its ruling on Estrelita's case, citing the case over and over and over, even to the point of saying that the office that seizes property in criminal investigations, that Estrelita's case must be disseminated to every office across the country so they know that animals are not goods and do not seize them the next time this happens. All right, so that's all. To conclude, you can see we're like really excited about this case in Ecuador. Developing pragmatic and implementable animal rights or animal welfare, if you choose that language, is urgent. Rights of nature are expanding. Despite the problems with rights of nature, we can use this framework to argue for individual animals. Animal protection advocates need to get a seat at the table for rights of nature, and also that it can assist in mainstreaming animal rights, because rights of nature seems to have a more accessible and accepted sound to it than animal rights. Haven't done a poll, but that's my sense from some of this material. So apologies, Manisha, we took a little extra time, but
thank you so much.
Okay.
Wow. Thank you so much, Macarena and Kristen, for that beautiful, vibrant, and just highly informative and stimulating lecture. So in the interest of time, I will take a few of my questions and kind of blend them and to get some of your responses, and then we will open it up for your contributions as well. Okay, so it's very exciting to hear about all of these developments, and I certainly see the reasons for the enthusiasm. Can I take you back, though, perhaps to my first kind of probably conceptual point? And I see it also as a pragmatic point, because it is kind of a point about the potential for this framework to kind of endure and to get to the results that we may want it to get to. So the first kind of topic is just to think about the naturalization that's inherent to the rights of nature framework. So this is a paradigm that's appearing to naturalize animals. And so I think it's fair to say that it's investing in, at least in Western epistemologies, the longstanding and harmful to animals separation of nature from culture, which has fueled a lot of that exploitation of naturalized entities. So, I mean, how confident can we be that it can be a promising, that any nature-centered strategy can be promising for animals, given that the naturalization of the other is at the core for animals and other non-human beings in terms of what they're experiencing, such that it might be difficult, really, as much as we can see some movement here in these cases on a long-term basis to kind of dissociate the long-standing animals nature inferior association and get that like out of our thinking and our legal thinking. And I just want to bring up a recent study about Ecuador and kind of the national plans that has kind of suggested or argued that from the time of the kind of President Correa interventions in 2006, you could see three types of discourses emerging for rights of nature just in Ecuador. One is like with all the movements and anti-capitalist discourse. One was kind of less on capitalism, more just on transformation of society, hopes and discourse. And the other was a much more anthropocentric development discourse, so kind of sustainable development. We can still accord rights to nature, but still have our economic advancements. And I mean, that author's conclusion was, at one point, these three were like competing for public attention, and now with the recent development plan, it's really the anthropocentric kind of discourse that is emergent. And that's one author's perspective, but linked back just kind of to the conceptualization of nature as always already being just an inferior place to start with. So just get your comments on that.
Okay, so I think the distinction between nature and culture is false. I mean, I think that it's caused a lot of problems that we see around us, like thinking that these two things are opposite. I think that it's easier to understand nature as an interconnected system where there are different types of beings. different animals. And within those animals, there are human animals and non-human animals. And within those animals, there are some animals that have cultures. And so I don't see that, like viewing it that way, I don't see that it would be thinking of animals as others, because humans are also part of nature. The problem is that we have always thought of ourselves as being separate from nature, and considering that certain groups, certain minorities, or certain animals, or even natural elements are nature, but the dominant human group isn't. So I think that's a problem, and it has led us to where we are. And regarding what you say about the discourses in Ecuador, the thing is that, for example, this is like gossip, but I spoke about Alberto Acosta. He was the president of the Constitutional Assembly for some years, and then he resigned. So at the beginning, he worked with Correa. He was his Minister of Energy or Economy. I can't remember, but he was an important figure. And now he writes against Correa, the president in those times, and now there are other presidents, but he was against it because Correa had like this plan of developing the good living and advancing and changing society, but then he was really supporting extractivism and multinational companies continuing the destruction. So there's a problem of Ecuador between the executive power, that is like the president, versus like society, like what society wants. So that is obviously a struggle, and we could say that probably in Latin America and in the world, companies are, and like the view of having sustainable destruction and sustainable development is the one that is winning, but not only in Ecuador, like in every country around the world. So I think it's not a problem of the rights of nature, but rather a problem that affects countries that haven't even talked about the rights of nature. You know, it affects environmental law, and it's just a matter of like society advancing and saying like, no, we need to stop. And for example, saying, you know, indigenous peoples are right, and we should apply the principle of good living that is based on a non-predatory living. So I don't know if that.
Yeah, and just, add, we've obviously only been able to give sort of certain narratives through this presentation, and there's definitely others. And one of the criticisms of Ecuador, and perhaps one of the reasons this turnover in the judiciary, they went to Article 71, is that, it was originally put in the Constitution for the president to be able to control giving away, mining license, so that he controlled what rights of nature meant. So, and there's a political story too. There's probably some tension between the different branches of government. There's so much, I think, that creates diversity of opinion within the country, and we've really just scratched the surface of that, and have just more focused on the cases.
Okay, thank you. So let me just segue that into a question about the mythification and romanticization of nature, which is part of what we're talking about here. So as many post-structuralist scholars working in animal studies, post-humanists have said, there is no such thing called nature. So it's not so much like a problem of how to define nature, that we get like all can represent it in all its diversity, but actually that there's nothing to define, because this is artificial binary, and it's just human projections onto this kind of sphere in our minds, and perhaps even in our hearts, of what we call nature. So would you kind of say that the rights of nature framework in the legal sphere is, kind of invested in this romanticization, and is that a problem for the strategy at all, or just, not really? What would your view be on it?
I think that to some extent, we're all probably postmodernists at a minimum. They're just they're words, and the reference is unstable. What is nature? Maybe it has a definition from one person to another, and as Macarena said, is it a hope that a new word can change things? So okay, the environment, that didn't work out so well. So now if we call it nature, do we get like a new start because we have a new word? So I do have some deep skepticism around all of that, and that, as you said, maybe it's kind of creeping back towards an anthropocentric position anyway, because who decides what the rights of nature are? I think all of that is probably true. And yet, on a practical level, maybe something can be achieved. And so I think for me, both of those things hold true at the same time. And there's a tension between them, but I don't know what I can't really, I can't resolve it.
Thank you.
So something interesting that came up during the Constitutional Assembly in Ecuador was that one assembly member said during one of the hearings said, hey, considering that tropical forests cover 40% of Ecuador, then we shouldn't protect them because like they cover cities, towns, and like also rural places. But like the Alberto Acosta, the president, kind of called him out for that and said like that's ridiculous, like we have to protect it. So it makes me seem that I think that maybe in Ecuador they're not thinking of like pristine places only, but they have a conception of nature that is expanded throughout the country. It's not only the Amazon where there's nobody there, and that is also false because there are people in the Amazon. I mentioned like 1,500 communities. So I think that their concept was like more that nature is in cities. And I would argue that like nature is like here, if you go to the bathroom, there's water coming out of the tap. So I think that the rights of nature could defend only pristine areas, but it shouldn't, because it will leave us where we are. That is like, hey, we destroyed here, but then let's not touch that national park. But that hasn't worked out.
What's the reason on the 40% is that if it covers so much territory, it must not need protection?
No, it was like, as it covers so much territory, like we won't be able to do anything. So we shouldn't protect it because we're living there. Like, how are we going to live in a city that has a tropical forest? How are we going to live?
Oh, it's more nature as those other places, right? Okay.
Right, getting to the attention. So just before we open up for questions, just to confirm or clarify, there hasn't been anything from your research that has correlated legally rights of nature with human rights. It's still kind of carved out for this non-human sphere, is that correct?
Well,
I mean, to say that our rights are rights of nature. Not that rights of nature relate to human rights, but that our rights are rights of nature.
Well, that's the question, right? If we're humans or part of nature, then do all of our rights, do they come under the rights of nature? And I mean, you could go to that position. I don't know if have we seen that statement? I'm looking at Ashton because we've had these discussions about our human rights of nature. I don't know if there's
so there's not an answer, like an exact answer, but some scholarly work in Latin America have said, like some authors have said that human rights should be rights of nature. So like every human right, so it should be exercised thinking about the rights of nature, even the right to vote. So when we have the right to vote and we go to vote, we should be thinking about like the rights of nature. Mm-hmm. So they have like that because they think like the rights of nature is like if we don't secure that, the planet is going to end and we're going to
more like it's an obligation on us to be constantly aware.
Like every human right should be interpreted like through the rights of nature.
I
so
see.
Even the right to vote.
I see.
Like the right to everything should be through the rights of nature, so that we could actually change the planet and the way we live and live in a completely different way. But that's like one opinion, obviously.
So perhaps more trying to contest the binary that it keeps humans out of it.
Yeah, I guess, and the idea that rights might clash, right? If you have the right to employment or the right to education, well, that right has to can coexist with the rights of nature and not violate it, or the rights of nature is on top. I don't know. Macarena has done this research so far, just trying to get a sense of who's conceptualizing this and what are they thinking and how's it being conceptualized, and that's of course a different question than how have these judges dealt with it, which has been a little more practical. But all of this is important because how are these conversations going to be pushed in which direction and whose voices are going to.
Exactly. Thank you so much for those replies. Let's open it up now for audience questions. And I guess we will ask everyone to do the format from the morning to please come and take the mic here to pose a question. MH, yes, please come up.
I was listening to your presentation and just pretty blown away as a person in North America, seeing this ruling. Animals are the subjects of rights. Animals have access to judicial protection, even with the proviso about like predation being protected. I can't imagine something like that here. So it seems really epic. To me, really blown away by that. But then I was just burning with curiosity about like what allowed this to happen in Ecuador. Like what is the balance of interests on the ground?
Yeah.
Like what is there like here in Canada, I think in the US too, it's like even, very tiny incremental proposals for change are met with just huge resistance, right? And they're, oftentimes the changes are so small. Are there farming interests that were opposed to this? Like, what was going on down there? Like, I'm just so curious to know, like, is there big ag there? Like, what, anyways, like, if you have any
Say something?
Yeah. So Latin America, has all the lobbies that exist in North America. There's the hunting lobby, there's the farmers lobby, like all those lobbies exist and they're strong there. But I think that in Estrellita's case, what happened was that of the 9 judges of the Constitutional Court, like 7 of them were like very vocal about the rights of nature. They were like really fans of the rights of nature, and some of them knew that there was going to be a change in the Constitutional Court coming up. So they were like saying, if it's my turn to leave, like that I am one of the main supporters of the rights of nature, I want to do something, like leave something like a good ruling here, because I'm going out and maybe the new judge that's coming in is really conservative and like hates the rights of nature. Like the one that wrote the dissent that even said that we shouldn't even refer to Estrellita by her name because animals don't have the right to an identity. So we should talk about Estrellita as like a woolly monkey, an animal, a specimen, but not as Estrellita, not with a name. So I think that played a part, and I think in Latin America it's also important that other countries in the region are like Argentina, for example, since Sandra's case of the orangutans case and Cecilia the chimpanzee case, that Cecilia was the first habeas corpus that was granted by a court, and Cecilia was transferred to a sanctuary and she currently lives there. And orangutan Sandra was also habeas corpus and she's living in the US in the Florida Center for Great Apes. After those judgments, and these are civil law countries, but they kind of started creating like precedent. And other lower courts started saying like, yeah, animals are subjects of rights. Animals are non-human persons. To the situation now in Argentina, there's like a judgment from this year regarding a dog that her name was Tita, and she was shot dead by the police because she barked at a police, and it was a criminal case. But the judge recognized the dog Tita as a non-human person, a subject of rights, and the non-human daughter of the human, like the owner, and recognized the owner as Tita's non-human father. So that court recognized on the one side non-human persons and subjects of rights, and on the other side recognized the interspecies family. And that's Argentina. And now, like, since I submitted the thesis in July, like there are like 6 new cases in Latin America regarding animals in some way that a court says, yeah, they're subjects of rights. And you could argue, yeah, but that hasn't changed anything. Well, Cecilia's life sure changed. She's living in a sanctuary. Sandra too. There are elephants that have been transferred to sanctuaries in Argentina as well. And even in cases like Tita that she died, those cases like are shared on social media and like influence other judges in Argentina, and they start like referencing each other. So it's kind of like a process of mainstreaming. So then courts in Ecuador know about Sandra and Cecilia, and they cite the cases. So it's like a thing that it's expanding.
And there is a sense we gather. I think Hugo also maybe thought this of some competition, but competition of wait a minute, we're the country of the Galapagos Island, and we're the nature protecting country, and look what they're doing. So there could be some sense of we're the ones with the rights of nature in the Constitution, and look, all the actions happening here. And so competition in a good sense, but that might be hard to track down. We have a lot of past yet to pursue on this, and we haven't spent time in Ecuador. Hugo has been our kind of partner on what's happening and how it's been received, but yeah,
Just amazing.
yeah.
Mm-hmm. Raj, please go ahead.
Okay, Roger's gonna throw cold water on all of this.
Oh, no, not at all. But this question I think follows really nicely. Wondering about the prospects for certain, rights of nature paradigms here in North America,
Yeah.
particularly the U.S., where we're seeing state legislatures sort of preempt, rights of nature being recognized by the courts. And so, with that as sort of a backdrop, my question is, I'm assuming that if Estrellita had been alive, the habeas corpus would have allowed her to be moved to a sanctuary.
Well, maybe.
Okay.
Yeah, I don't think we know for sure.
And I want to sort of put this into conversation with the Coven case, which really emphasized that humans constitutionally there have a right to nature as opposed to nature actually having rights in and of itself. And I'm wondering if you see a distinction between those two sort of frameworks about frameworks to protect the interests of animals. So that animals as components of nature which have rights versus animals which are components of nature to which we have rights to, in light of potential blowback to this notion that nature in and of itself has rights that is not informed by our interests in it.
Yeah, well, the latter is, exactly why we think that we should be able to see, a species out of its natural environment in a zoo. Like, oh, I have a right to nature, to get it, right, to hold it, to possess it. I don't know that. I don't know how to answer that question. I don't feel like we've seen that turn.
I didn't have a chance to explain the sloth case.
Oh, good. Yeah, that's good.
What the sloth case, and it's one of the recent cases in Ecuador, and it was similar to Estrellita in the sense that like a baby sloth fell out of a tree because his mom was killed by a feline, and he was on a woman's farm. So the woman took him and raised him, and the woman worked at a restaurant. So she took him to the restaurant, and so the sloth, whose name is Cookie Brown, was living inside a restaurant, and like they built like a little platform for him like near the ceiling, and he lived there inside the restaurant. So a habeas corpus, the agency confiscated him. The woman presented a habeas corpus, and the lower court and the Court of Appeals denied the habeas corpus, and applying Estrellita's judgment said, hey, Cookie Brown, the sloth, has, through the rights of nature, has a right to integrity, a right to life, the right to live in his own habitat, like to freedom. So the court said, we're going to grant temporary custody to the zoo. So they apply Article 71 that says that nature has to be rehabilitated, regenerated, blah, blah, blah. So that means that the zoo has to rehabilitate the sloth Cookie Brown and reintroduce him to his habitat. Maybe if it weren't for Estrellita's case, the judges would just say, leave him in the zoo, like as it was happening before. But thanks to Estrellita's case, now those judges are thinking like, okay, the Constitutional Court says we have to consider the situation, the circumstances of the animal, and that animal has a right to live in his own habitat and to be free. So,
I mean, obviously, we prefer that it wasn't a zoo during the rehabilitation, but that point aside, right? That you can see the right moves happening there. Claire, hi.
Hi, two thoughts. Firstly, in relation to the rivers, and I recognise, but this might be too early to talk about, but you mentioned liabilities, that the rights of nature also incurs liabilities upon the nature. And I wondered, given the historical context of like animal trials in Europe and that kind of thing, what that might look like, what issues you potentially foresee outside of that. And also I wondered from a common law perspective, is this something that can be easily transferable to common law contexts? Because you said this is a civil law context. I mean, especially in the UK, we don't even really know what's in our constitution, let alone have a bit about animals. So I just wondered how, there are two thoughts there. So,
Well, Roger mentioned the U.S., right? So we didn't pick up on that, but next week I'm participating in the American Bar Association Department section on the energy and natural resources, but somehow they put together a rights of nature panel, and the other participants are lawyers from in tribal courts. So these are tribal court decisions about rights of wild rice and salmon, rights of salmon. Of course, the rights of salmon are so that people have more salmon to eat. But all that is to say, there are people who are, we're starting to know more about what's happening in the U.S. There's been a lot of really neglect of thinking about these questions, not by Native Americans at all, but just in these kind of more international communities that think we don't have this, we don't have any of this in the U.S. when really there is. It's maybe happening in tribal constitutions or in I quote in one of my articles, like the Navajo Civil Code recognizes the rights of nature. So, but there have been attempts in the U.S. by municipalities to establish the rights of nature to prevent corporations from operating, and those have been struck down as unconstitutional. So you have to have the right kind of language. Liabilities, yeah, that's a good point. So these rivers in Awatuera have bodies, individual, like a governance body of Maori individuals who sort of watch out for it and make decisions about it. So I don't know, Ashton, do you know what would happen if there was an injury in the river? Or has there been much in the press about the it's unfair.
I'm not sure.
Ashton is only half New Zealand, only a half Kiwi, and I'm looking at him to answer that question.
I'm actually not sure if there's been. There was definitely discussed to the concern of what would we do with this. I remember talking to someone about that. But I don't know. There could have been developments post that legislation on the Whanganui River. I don't know if there has been a discussion of liability for flooding damage.
Right, exactly.
Envision, if they, did have some kind of a regime where this governing board would have to, have some sort of a fund that would be able to, pay for damage caused by the river. And, I don't know it.
Yeah.
Because that's now money flowing away from, stewardship funds. And now we're going to, pay surrounding communities for that. Our resources it could be very, very.
But it's an all Maori body that is kind of governing, making decisions about the river, protection, right? We haven't seen. Forrest hasn't done anything yet, I guess. I don't know. We'll have to wait and see. But it's a good question. I mean, it's a very lawyerly question. It's really good.
Okay, we have
And what about tax
lovely
payments,
and
right?
last quick question
Okay, yeah.
with the quick reply.
Yes,
Thank
we
you.
know it's time
So,
for a break.
My
yeah.
interest is in the wording of the sentient beings being included in constitutional law. It's my understanding. I learned that Great Britain, I think, just this
The
past
sentient,
year,
yeah.
put that
Sentient
description in their law, and apparently it's going to change quite significantly their penalties and their laws and how they enforce them. I don't know how they're going to do it, but and then I found out that I think it's 2 provinces in our country have sentient beings in their provincial laws.
In Canada.
Yeah, Quebec and maybe BC. And so my question is with regards to horse slaughter, actually, from that angle, but it could go to any animals. Seeing as they recognize sentient beings, could lawyers not argue the case for, since they've used that wording, to say that their rights are being affected? And why doesn't our government follow these precedents that are being set? That's a real good one.
Well, I can just tell you, like, that with the UK Sentience Act, it has to do with Brexit, because the European, the TEFU recognizes animals as sentient beings, and so now the UK is trying to figure out, well, are we, what are we going to do, right, in light of that? That is not a governing document anymore. So the Sentience Act is really not doing anything that didn't already exist previously. But there's talk of legislation. So is the UK going to go up, right, now that they're not part of the EU in terms of animal protection? Are they going to go down? They're going to stay the same? But sentience law just stuff, I think it can do nothing. It can do something. I think it's a very malleable term.
Well, when we have
Patty, I'm sorry. I invite you to take this up, right? We're just a bit over our time.
Macarena, have you seen, come talk to Macarena afterwards about if we've seen sentience have real teeth in terms of results.
Okay, thank you all so much for your attention. Please join me for the thanking. Thank you, Kristen. Thank you, Macarena, for that outstanding session.
Right. Thank you so much. Sorry, we give you such a hard time as a moderator.